Breaking news right now. A judge says there is probable cause to hold the Trump administration in contempt. This is in regards to the case of deporting Venezuelan migrants, despite that judge's order in his court to turn the plane around. CNN chief legal correspondent Paula Reed joins me now. Paula, what exactly is the judge saying?
Look, Dana, this is huge. We've been waiting for this opinion. Now, the judge here is still deciding punishment and the next steps. He is giving the Justice Department a chance to weigh in here. But this case, this question has, as you know, become a political flashpoint. President Trump has repeatedly attacked this judge, James Boasberg, even calling for him to be impeached. Now, much of this started last month on March 15th. The president had invoked the Aliens Enemies Act to facilitate a deportations of Venezuelan migrants. The government alleges were affiliated with a gang. Litigation commenced over the weekend, and these planes that were already carrying migrants were eventually grounded.
Good to see you again, Jack here. Let's get started. A judge holding Trump in contempt with marshals standing by to arrest him are completely false. The dramatic narrative of imminent detention is powerful, but entirely fabricated. No such court order exists. The danger lies in how these videos weave small fragments of real legal cases into a dramatic, false narrative, misrepresenting what actually happened. Simple falsehoods travel faster than complex truths, and millions are being convinced of something that simply isn't true. The actual legal situation involving the former president is far more complicated and far less dramatic than the viral videos suggest. There have been multiple contempt findings against Trump over the years, but they involve completely different cases, different judges, different legal issues.
But then when the judge ordered these to be flown back to the United States, they continued from Honduras, where they had stopped, onto El Salvador. Now, the judge has suggested that this was a deliberate attempt to defy his order. But Justice Department lawyers and sources I've spoken with disagree. They believe that a district court judge did not have jurisdiction over the acts of the administration once they're in international territory. Now, I want to read some quotes from this opinion. The judge says, as this opinion will detail, the court ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. The court does not reach such a conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses has been satisfactory. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn.
And most importantly, different outcomes that bear no resemblance to the dramatic narrative being pushed across social media. One case involved gag order violations during a trial, another involved failure to comply with a subpoena, and a third involved an administrative matter that was later overturned on appeal. None of these cases are connected to each other, none of them resulted in detention, and none of them have marshals standing by to arrest anyone. Yet, the viral videos have somehow managed to present these three separate, unrelated situations as if they were all part of a single, unified pattern of contempt that has finally prompted judicial action, leading to imminent arrest. The most egregious distortion in these viral videos is the claim that marshals are currently standing by
an oath to uphold it. Now, there is a little chance that the Justice Department is going to deviate from its belief that, again, district court judges cannot dictate what they do once they are in either international skies or on the ground, which is what happened here. These planes landed in Honduras. But this is notable because here you have a federal judge holding the administration in contempt, as for several months, Dana, we've been talking about concerns about whether the administration would at any point intentionally defy a court order.
Really remarkable stuff. Paula, thank you so much for breaking that down for us. My panel is back with us. And Jeff Zeleny, I know this just happened, I don't know, a few minutes ago. Are you hearing anything yet from Trump sources?
Not yet from the White House officially. They likely are waiting for the Department of Justice to respond. But look, this is something that the White House has made clear. The president has made it clear, certainly people who work around him, their view of Judge Boasberg, who we should point out was elevated by President Obama, but was initially appointed by George W. Bush. He's viewed as a straight shooter. He has a lot of conservative friends and allies as well, including some on the Supreme Court, his college roommates, etc.
Ready to detain the former president at a moment's notice. This is not just an exaggeration or a misinterpretation. It is a complete fabrication with no basis in any actual court order or judicial proceeding. United States Marshals are federal law enforcement officers who perform specific functions in the judicial system. They serve court documents, provide security in federal courthouses, protect judges and other court officials, and execute court orders. But they do not stand by waiting for judges to order arrests without having received specific orders to do so. For marshals to detain anyone, a judge must issue a specific order directing them to take that action.
So, look, I think that this is the question here, it seems to be, and this is a 46-page ruling, as we just were looking through it. Is there jurisdiction here for him to act? Because it was moved to a Texas court, but Judge Boasberg is saying that there clearly is in his mind. So I think that this is going to be one more example of the White House pushing back at judges. We've heard what they've said about Judge Boasberg. The president has been very sharply critical of him without really knowing his true body of work, I think.
Or caring. Just more to what is underneath all of this, and that is just a reminder that there were planes that left for El Salvador, and this was after Judge Boasberg said, no, you have to wait, they can't go. And then they went anyway. The dispute is whether or not the planes were already in the air, and if they were, whether or not a federal judge has jurisdiction to turn them around if they're over international waters.
No such order has been issued in any of the cases involving the former president. The claim that marshals are standing by is simply made up, invented out of thin air, to add dramatic tension to a story that otherwise lacks any actual tension. The gag order case that forms the foundation of these viral claims deserves careful examination because it's the most recent and the one that the videos rely on most heavily. During the hush money trial in Manhattan, the presiding judge imposed a gag order restricting what the former president could say publicly about jurors, witnesses, prosecutors, court staff, and their families. These restrictions are standard in high-profile cases to protect the fairness of the trial and prevent intimidation.
The Trump administration argues, no, they don't. This judge is not buying that. He says that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. It is lengthy, but one of the things he did say in here that he's offended that the Trump administration or people inside the DOJ seem to be, quote unquote, joking about this.
Look, we are not even 100 days into this administration, but it has been clear from pretty much the beginning that we were in a situation where the White House and the courts are on a collision course, and it's going on a bunch of things we were talking about earlier in the program, where this man who's in El Salvador, there's a court order to bring him back, and the Trump administration has interpreted that to say, well, if he gets back, then we would take him in, but then we deport him again. They are finding legal ways through a lot of these things so far. We don't know what will happen as these challenges keep on going. It's, by the way, also with what's happening with press access in the White House. The White House was...
or harassment of participants. The former president violated this order multiple times, making public statements that the judge determined crossed the line. After finding 10 separate violations, the judge imposed fines of $1,000 per violation, totaling $10,000 in penalties. The judge also warned that future violations could result in jail time. This warning is where the viral videos get their claim about detention, but they completely distort what the warning actually means. A judicial warning about potential future consequences is fundamentally different from imposing those consequences. When a judge warns a defendant that continued violations could result in jail, the judge is signaling that the behavior must stop and that escalation is possible. But the warning itself is not a detention order. It does not authorize marshals to arrest anyone. It does not mean the defendant is currently in jail or about to be taken into custody. It means exactly what it says. Future violations could lead to jail. In this case, the former president paid the fines, the trial proceeded, and the judge did not impose any jail time for the violations that had already occurred. The warning about future jail was just that, a warning, not a sentence, not an arrest warrant, not a detention order. The civil contempt case from earlier years is another element that the viral videos have distorted to fit their narrative. In that case, a judge found the former president in civil contempt for failing to comply with a subpoena from the New York Attorney General's office. The subpoena demanded documents related to an investigation, and the judge determined that the former president had not adequately complied. Civil contempt is different from criminal contempt in important ways. The purpose of civil contempt is to compel compliance with a court order, not to punish past violations. The judge imposed escalating fines of $10,000 per day to pressure the former president into providing the requested documents. This was a financial penalty designed to encourage cooperation, not a criminal sanction meant to punish misconduct. Once the former president eventually complied with the subpoena and produced the documents, the judge lifted the contempt order and the fines stopped accumulating. The former president paid the fines that had already accrued and the matter was resolved. This was not a detention situation. No marshals were involved and the contempt order no longer exists. The third case that the viral videos reference involves an entirely different matter, one that didn't even involve the former president personally, but rather the Trump administration. A federal judge considered whether the administration had violated court orders regarding deportation procedures. The judge found probable cause to consider contempt, which is a preliminary finding that there might be grounds for contempt, not a final determination that contempt actually occurred. The administration appealed this preliminary finding, and the appellate court ultimately vacated the contempt finding, meaning it was overturned and no longer has any legal effect. The court determined that there was no contempt, the administration was cleared, and the entire matter was resolved. This case had nothing to do with gag orders, nothing to do with subpoenas, nothing to do with detention, and nothing to do with marshals. Yet the viral videos have included it in their narrative as if it were evidence of a pattern of contempt that justifies imminent arrest. The combination of these three separate, unrelated cases into a single narrative of third contempt is a classic example of the kind of manipulative editing that drives viral misinformation. The creators take real events, strip them of their context, ignore their different legal foundations, ignore their different timelines, and present them as if they were all part of a single pattern. The 2024 gag order case, the 2022 subpoena case, and the 2025 deportation case are presented as if they were three contempt findings against the same person for the same type of conduct, leading, inevitably, to detention. This is fundamentally dishonest. These are different cases with different judges, different legal issues, different parties, and different outcomes. Two of them are resolved and no longer exist, and one of them involved fines, not detention. None of them support the claim of imminent arrest. The constitutional and legal processes involved in contempt and detention are designed to be deliberate and to include multiple safeguards against arbitrary action. A judge cannot simply order someone detained without following established procedures. In criminal contempt cases, the defendant must be given notice and an opportunity to be heard. The judge must make specific findings about the violations and must impose penalties that are proportionate. Jail time for contempt is typically reserved for serious or repeated violations. And even then, the judge must issue a specific order directing detention. In civil contempt cases, the focus is on compliance, not punishment. And detention is typically considered only as a last resort when all other means of obtaining compliance have failed. None of the cases involving the former president have reached this level. The gag order violations resulted in fines, not jail. The subpoena case resulted in fines that stopped when compliance occurred. The deportation case was overturned on appeal. There is no basis for the claim that detention is imminent or that marshals are waiting to act. The role of the appellate process in the American legal system is another crucial element that the viral videos ignore. When a lower court makes a ruling, Parties have the right to appeal that ruling to a higher court. The appellate court reviews the lower court's decision and can either uphold it, modify it, or overturn it. In the deportation case, the appellate court overturned the contempt finding, meaning the lower court's decision no longer has any legal effect. Once a ruling is overturned, it cannot be used as a basis for further action. The idea that someone could be held in contempt for something that was later overturned on appeal is nonsensical. The appellate court's decision effectively erased the contempt finding, meaning it never happened for legal purposes. Yet the viral videos treat this overturned contempt as if it were still valid and still supports their narrative of imminent detention. The financial penalties imposed in the contempt cases are also important to understand because they demonstrate that the courts were focused on monetary sanctions, not detention. In the gag order case, the judge imposed fines totaling $10,000, which the former president paid. In the subpoena case, the judge imposed fines of $10,000 per day, which eventually totaled $110,000 and were paid after the former president complied with the subpoena. These are significant financial penalties, but they are not detention. The courts had the option to impose jail time if they believed it was warranted, but they chose not to. The judges in both cases determined that fines were sufficient to address the violations and to encourage future compliance. This is not a situation where the courts were eager to detain the former president. It's a situation where the courts exercised their authority in measured and proportionate ways. The warnings about future jail time in the gag order case have been particularly distorted by the viral videos. The judge warned the former president that continued violations could result in jail, but the judge did not impose jail for the violations that had already occurred. This warning was a clear signal that the judge was losing patience and that escalation was possible if the behavior continued. But the warning itself is not a detention order. It does not authorize marshals to arrest anyone. It does not mean that jail is imminent. It means exactly what it says. Future violations could lead to jail. The former president could have continued violating the gag order and risked jail, but he did not. The warnings served their purpose, and the matter was resolved without any detention. The viral videos present the warning as if it were a detention order, completely ignoring the crucial distinction between a threat of future consequences and the imposition of current consequences. The specific legal terminology used in these cases is also important to understand because the viral videos deliberately use vague or misleading language to create false impressions. The term contempt itself can mean different things in different contexts. Criminal contempt is a punitive sanction for past violations. Civil contempt is a coercive sanction designed to obtain compliance. A finding of probable cause for contempt is a preliminary determination that there might be grounds for contempt, not a final determination. A warning about potential jail time is a threat, not a sentence. The viral videos use these terms interchangeably, treating a warning as if it were a sentence, treating a preliminary finding as if it were a final determination, and treating civil contempt as if it were criminal contempt. This linguistic sleight of hand is central to the deception because it allows the creators to present a dramatic narrative while using terms that sound serious and official to unsuspecting viewers. The specific details of the gag order case are important to understand because they show the scale of the violations and the proportionality of the judicial response. The gag order prohibited the former president from making public statements about jurors, witnesses, prosecutors, court staff, and their families. These restrictions are necessary in high-profile cases to prevent intimidation and ensure a fair trial. The former president violated this order 10 times, making public statements that the judge determined were violations. The judge had to balance the constitutional right to free speech with the need to protect the integrity of the judicial process. The judge determined that $1,000 fines per violation were appropriate, totaling $10,000 in penalties. The judge also warned that future violations could result in jail, which was a clear signal that the court would escalate if the behavior continued. This is a standard judicial response to repeated violations, not an indication that detention is imminent. The specific details of the subpoena case are also worth examining because they show how civil contempt works in practice. The New York Attorney General's office issued a subpoena for documents related to an investigation. The former president did not comply with the subpoena, prompting the judge to find him in civil contempt and impose daily fines of $10,000. These fines were designed to pressure the former president into complying, and they worked. Once the former president complied with the subpoena, the fines stopped accumulating, and the contempt order was lifted. The total amount paid was $110,000, which is significant, but represents the cost of non-compliance rather than a criminal penalty. This is how civil contempt works. It's a financial pressure mechanism designed to obtain compliance, not a punitive measure designed to punish misconduct. The specific details of the deportation case are also relevant because they show how appellate courts can overturn lower court rulings. The judge found probable cause to hold the Trump administration in contempt for allegedly violating court orders about deportation procedures. The administration appealed this finding, and the appellate court reviewed the case. The appellate court determined that there was no contempt, vacating the lower court's finding and clearing the administration. This is a standard appellate process, where a higher court reviews a lower court's decision and either upholds or overturns it. Once the appellate court vacated the contempt finding, the contempt no longer existed for legal purposes. The administration was cleared, and the matter was resolved. There is no contempt finding from this case that can be used to support any claim about the former president's legal status. The cumulative effect of these three separate cases is not a pattern of contempt leading to detention, but rather a series of isolated legal skirmishes with different outcomes. The gag order case resulted in fines, not detention. The subpoena case resulted in fines that stopped when compliance occurred. The deportation case was overturned on appeal. None of these cases resulted in detention, and none of them support the claim that marshals are standing by to arrest the former president. The viral videos have combined these cases to create the illusion of a pattern that does not exist, presenting fines as if they were the prelude to detention and preliminary findings as if they were final determinations. This is the essence of the deception, taking real events and presenting them in ways that fundamentally misrepresent their legal significance. The motivations of the people creating these viral videos are also worth considering, because they explain why such blatant misinformation is being spread so widely. The attention economy rewards content that generates strong emotional responses, and nothing generates a stronger emotional response than the claim that a former president is about to be arrested. These videos are optimized for engagement with dramatic thumbnails, urgent headlines, and escalating claims that keep viewers watching. The creators know that the truth is far less exciting than the fiction they're presenting, but they also know that fiction gets views, shares, and comments in ways that nuanced legal analysis never will. This is the fundamental problem with the current media environment. The incentives favor misinformation over accuracy because misinformation is more engaging and more profitable. The consequences of this misinformation are significant and damaging to democratic discourse. When millions of people believe that a former president is about to be arrested and that arrest does not happen, they become cynical about the political system and suspicious of all political information. They may also become more susceptible to other forms of misinformation because their trust in traditional sources of information has been eroded. The cycle feeds on itself, with each false claim making it easier for the next false claim to be believed. This is how misinformation destroys the shared understanding of reality that is essential for democratic governance. When people cannot agree on basic facts, they cannot have productive conversations about policy and governance. The pattern of false claims about imminent arrest during the Trump era is well established and has been repeatedly debunked by fact-checkers and legal experts. Claims that the former president was about to be arrested have been made dozens of times over the years, and each time they have proven to be false. Yet, each new claim generates the same cycle of viral spread, public confusion, and eventual disappointment when the predicted arrest fails to materialize. The current claims about contempt and marshals fit this pattern perfectly, generating excitement and engagement, but ultimately resting on a foundation of misrepresentation and legal misunderstanding. The only way to break this cycle is for viewers to become more skeptical of dramatic claims and more willing to verify information before accepting it as true. The legal system itself provides the ultimate answer to the question of whether detention is imminent. If a judge had actually ordered the former president to be detained, that order would be a matter of public record. Court orders are not secret. They are filed with the court and can be accessed by anyone. The fact that no such order exists in any of the cases involving the former president is compelling evidence that the claims about imminent detention are false. Similarly, if marshals had actually been ordered to stand by and detain the former president, that would also be a matter of public record. Marshals operate under court orders, and those orders are part of the official court record. The absence of any such order is conclusive proof that the claims are false. The specific names and dates involved in these cases are often misrepresented in the viral videos to create a false sense of immediacy. The cases are presented as if they happened recently or are happening right now, when in fact, they occurred over a period of years. The 2024 gag order case happened early that year, the 2022 subpoena case happened years ago, and the 2025 deportation case happened later that year and was resolved. By presenting these cases as if they are all current, the viral videos create the false impression that there is a pattern of ongoing contempt that is leading to detention. In reality, 2 of the cases are completely resolved and no longer exist, and one of them resulted only in fines. The urgency and immediacy are entirely manufactured. The legal principle of finality is also important to understand because it explains why older contempt findings cannot be used to support current detention claims. Once a case is resolved, whether through compliance, payment of fines, or appellate reversal, it is over. The contempt order no longer exists, and the person who is held in contempt is no longer subject to any sanctions. The 2022 subpoena case was resolved when the former president complied with the subpoena and paid the fines. The contempt order was lifted and the matter was concluded. The 2025 deportation case was resolved when the appellate court overturned the contempt finding. The contempt no longer exists. These resolved cases cannot be used to support any claim about the former president's current legal status because they are no longer active. The specific allegations in each case are also important to understand because they show that the cases are not related to each other. The gag order case involves statements made during a trial that violated the judge's restrictions. The subpoena case involved failure to produce documents to the New York Attorney General. The deportation case involved the Trump administration's procedures for removal flights. These are completely different factual situations, involving completely different legal questions, and being decided by completely different courts. There is no unified pattern of contempt, no single legal issue that connects all 3 cases, and no coherent basis for saying that they represent a pattern of behavior that would lead to detention. The way these viral videos present the cases, as if they were all part of a single, coordinated campaign against the former president, is another example of the manipulation that drives misinformation. The videos suggest that multiple judges in multiple courts are all working together to hold the former president in contempt and ultimately detain him. This narrative of judicial coordination is completely false. Judges operate independently, and each case is decided on its own merits. The fact that different judges in different cases have made findings against the former president does not indicate any coordination. It simply indicates that the former president has had legal troubles in multiple contexts. The viral videos present this as evidence of a conspiracy, but it is simply evidence of legal conflicts. The practical implications of the false claims about imminent detention are significant because they affect how people understand the political landscape. When millions of people believe that the former president is about to be arrested, they may make decisions based on that belief, such as whether to support or oppose the political process, whether to trust institutions, and whether to engage in political activity. These decisions have real consequences for democratic participation and governance. The misinformation does not just misinform people, it also misdirects them, leading them to focus on false narratives rather than real issues. The result is a public that is less informed and less able to make good decisions about the future of the country. Always meet dramatic claims, imminent arrest, coordinated removals with skepticism. The attention economy rewards exaggeration, but truth is often less exciting. Verify court orders and sources before believing narratives that seem designed to provoke rather than inform.